So we're back on YouTube. Okay, let's get on the record. Okay, we're now calling Douglas County case number 2020 JV4. This is State of Kansas versus Caleb Tullis. Most appearances are going to be by Zoom unless otherwise noted. The State of Kansas appears by Ms. Moody, Senior Assistant District Attorney. Caleb appears by Zoom and by his attorney, Ms. Blair, who is present before the court. Mother is present by Zoom, Ms. Kelly, and Mr. West is present from Douglas County Youth Services. I think that's everybody. We're on today to take a plea. Ms. Moody, is the state ready for a plea today?
Yes, Judge.
All right. Ms. Blair, is your client ready for a plea today?
Yes, Your Honor.
All right. Give me 1 second. Okay. So first, actually, Ms. Blair, can I chat directly with Caleb for a little bit here? So Caleb, can you hear me okay?
Yes, sir.
Okay, so want to talk about some of this paperwork with you. The first thing is I've got in my hand what we call a written waiver of physical presence for plea hearing, and there's a spot, 2 spots actually, for Caleb Tullis' signature, and somebody wrote Caleb Tullis there. Was that you?
Yes.
Okay. The significance of this piece of paper is that you have a constitutional right to appear before the court in person for the court to accept your plea. What this piece of paper says is you're prepared to waive that right and do this by Zoom. Does that make sense?
Yes.
Is that what you want to do today?
Yes.
Okay, thank you. Next up, and is there a written plea agreement? There it is. And Ms. Moody, I'll ask you first. Is the plea agreement in front of me is that Caleb will plead guilty or no contest to count 2, criminal use of a weapon, class A, non-person misdemeanor. Count 1 would be dismissed, letter of apology to be written to the school, mental health evaluation, and that Caleb would agree to the maximum term limit for probation. Is that your understanding of the plea agreement?
Yes, Judge.
Okay. Ms. Blair, is that your understanding of the plea agreement? All right. So, Caleb, did you hear all that I just went through with Ms. Moody and with your attorney?
Yes, sir.
And is that your understanding of the plea agreement?
Yes, sir.
Okay. So, the next thing I'll ask you is on the second page of this document, the plea agreement, there's a place for Caleb Tullis' signature, and somebody named Caleb Tullis wrote their name there. Was that you?
Yes, sir.
Okay, great. Finally, I've got a plea advisory. And somebody wrote the initial CT all over it, like all up and down it. Was that you?
Yes, sir.
I've also got on the last page a place for Caleb Tullis' signature, and there's a signature there. Is that your signature?
Yes, sir.
Okay. So the thing you need to understand here, Caleb, is that you have a constitutional right to a trial. You've been charged presently you've been charged with theft and criminal use of a weapon. You have a right to a trial on those charges. Do you understand that?
Yes, sir.
If you plead, which is what these documents say, if you plead guilty or no contest and the court accepts your plea, the court would just find you guilty and we'd keep moving on to the next phase of this process. There would be no trial. Do you understand that?
Yes, sir.
So at that trial, you have various rights that you could exercise to whatever degree you like. But if we don't have that trial, you'd be waiving those rights along with it. Do you understand that?
Yes, sir.
Okay. So some of those rights include, for example, the right to a jury trial. Do you know what a jury is?
No.
It's okay. People go to law school to learn this stuff. You might have seen it in the movies. A jury is where the court would bring in people, a jury of your peers, either 6 or 12 people, and they would sit in the courtroom and they would listen to all the evidence and they would decide if you're guilty or not guilty.
Okay.
Does that make sense?
Yeah.
You might, as I say, you might have seen it on TV where they stand up in the box and say, "We, the jury, find the defendant guilty or not guilty or whatever." You know what I mean?
Yes.
Okay. So you would have the right to that at a trial. This piece of paper says you want to waive that right. Is that what you want to do?
Yes.
Also, at a trial, you would have the right to testify. So you could be sworn in, take the oath, come up here and tell your side of the story if you wanted to. You would not have to, but you would have the right to do that at a trial. If there isn't a trial, you will not have that right. You still with me?
Yes, sir.
Also at a trial, you would have the right to say nothing at all. You'd have the right to be totally silent, and the court could not infer that you're guilty because of that. You understand that?
Yes, sir.
You also would have the right to confront witnesses against you. So, for example, if the district attorney brought in evidence or witnesses to testify, you and your attorney could cross-examine those witnesses. If there's no trial, though, you lose that right. Okay. You have the presumption of innocence. You ever heard of innocent until proven guilty? You ever heard that before?
Yes.
Okay, so that's you. You're innocent until proven guilty. Right now, you're not guilty. If the court finds you guilty, though, again, there's no trial. We just keep moving on. The district attorney's office has the burden of proof. What that means is they have to prove that you're guilty. You don't have to prove that you're not guilty. Does that make sense?
Yes, sir.
Okay. Do you understand that if the court finds you guilty, and if the district attorney's office can provide a factual basis, like I said, there'd be no trial. The court would just find you guilty. We keep moving on. That finding, that adjudication, would become a part of your criminal history going forward. Do you understand that?
Yes.
So, hypothetically, in the future, let's say you're being sentenced by some other judge, or by me for that matter. They're going to see that you have a criminal history as a result of this. Do you understand that?
Yes, sir.
Okay. So I mentioned sentencing. Do you know what a sentence is, Caleb?
Yes, sir.
Can you give me an example of a sentence?
Are you talking about like getting sentenced back to JDC or like probation?
Yeah. Those are two good examples, actually. Very, very good examples. So the court can sentence you to any number of different things. Some of them might be JDC, like you point out. Some of them might be probation. The court could order you to house arrest. So you've dealt with some of this stuff already in your conditions of release. The court could also order you to pay restitution. The court could order you to do charitable service or community service. The court could suspend your driver's license. The court could order you to attend some kind of therapy or treatment. In your case, there was mention, where did I put it? I've got too many papers in front of me, Caleb. One of them is for you to write a letter of apology. One of them is for you to obtain a mental health evaluation and follow recommendations. So those are things that might be part of a sentence. And in your case, it sounds like they're likely to be. Do you understand that?
Yes, sir.
The court could also, order you to take mandatory random drug testing, for example, or other treatment options. There might be educational elements to your sentence. But it is important you understand that your sentence could be very light, might be some kind of very easy probation. It also could involve what is essentially jail time. Do you understand that?
Yes, sir.
Okay. Do you understand that the court is not a part of your plea agreement, meaning I don't have to go along with this plea agreement?
Yes, sir.
Did you have enough time to talk about this plea with Miss Blair?
Yes, sir.
Do you have any questions about this document?
No, sir.
Has anybody made any threats or promises to you to get you to plead guilty or no contest?
No, sir.
Okay. All right. So let me ask you, Caleb, how would you like to plead to one count of criminal use of a weapon, a Class A non-person misdemeanor in violation of Kansas Statute 21-6301A14? Guilty, not guilty, or no contest?
Guilty.
Let me ask you a question, Caleb, and I don't mean to disagree with you, but did you mean to plead no contest?
No.
You mean to plead guilty?
Yeah.
Was that your understanding, Ms. Blair?
Your Honor, if I could have a minute to speak with him.
Sure, that's fine. Let me do that. Let me put the room. So this is awkward because I'm doing my own technical support. I'm going to put, first of all, we'll go off the record. We'll do that first.
Wait a minute. Wait a minute.
So I'm going to put the room, and I'm going to put Caleb. Into the breakout room. Pardon me, the court was muted and was talking into the microphone, and no one could hear me except for Ms. Blair. We're back on the record in Douglas County case number 2020 JV4. The matter of Caleb Tullis, all appearances are the same. The court took a brief recess so Ms. Blair could chat with Caleb privately. Ms. Blair, does it make sense for me to just ask Caleb what his plea is again? So Caleb, I'll ask you that question again after you had a chance to talk with Ms. Blair. How would you like to plead to one count of criminal use of a weapon, a Class A non-person misdemeanor, guilty, not guilty, or no contest? Can you hear me, Caleb?
No contest.
All right, thank you. Ms. Moody, can the state provide a factual basis?
Yes, before I do that, however, I was looking at the complaint. The complaint has the wrong subsection of the statute. So
Okay.
right now, the way it's charged is 6021 6301 A14. It should be A11. And so Caleb has knowledge of what that is. A11 says criminal use of weapons is knowingly possessing any firearm by any person other than a law enforcement officer in or on any school property or grounds upon which is located a building or structure used by a unified school district or an accredited non-public school for student instruction or attendance or extracurricular activities of pupils enrolled in kindergarten or any of the grades 1 through 12, or at any regularly scheduled school-sponsored activity or event, whether the person knows or has reason to know that such person was in or on such property or grounds. So that is the correct statute, same level, a non-person misdemeanor.
Well, I appreciate you bringing that up, Miss Moody. Miss Blair, I guess my first question is, do you want another minute to talk to Caleb privately?
Yes, Your Honor.
Okay.
We were under the impression that the A14 was the correct subset.
That's certainly fine. Obviously, if we're going to make a potential change here, we'll go off the record and we'll do the same thing we did before. Court's getting better at it. See everybody in a moment. We're off the record. Miss Blair, if you push that button when you're ready.
It hurts. Yeah, I don't think it was less than 12 inches though, was it? Yeah, which is, I think the barrel length has to do with the shotgun, not a regular gun. I mean, yeah, he's getting the benefit of that, but the A14, I just don't, I don't like that. I mean, I think it needs to say that it was on school property. So, I mean, he'll get the benefit of that, but I just can't, the 12 inches has to do with the shotgun. So, and I didn't realize that when I was, Bryant charged it, so I'll blame it on him because I didn't really pay that much attention to what subsection he used. So, yeah, so it's going to be, I mean, it's going to be, it's to his benefit, but I'd rather have it say what it is. So, okay. 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 All right. Bye.
We're all back. We're back on the record in 20 JV4. All appearances are the same. The court took another brief recess for Ms. Blair to chat with Caleb. Ms. Blair, what happens now?
So, Your Honor, I took the chance to speak with Ms. Moody during our break. Basically, she had wanted it to be charged under subsection A11, which is fine with Caleb and myself. The thing is that does change the classification of the crime to a B misdemeanor. So
As opposed to an A.
As opposed to an A.
Guessing you're not going to argue with that.
No, we have no objection to that. If the court's willing to proceed with everything today, then we'd be willing to do that.
So, Ms. Blair, I'll ask you, and then I'll ask Ms. Moody. Do you care if I just take my pen and interlineate on the plea agreement and the plea advisory, making it A11 and making it a Class B instead of a Class A.
I am fine with that.
Ms. Moody, do you have any concerns about that?
No, Judge, we'll be filing an amended information.
Okay, so I'm going to white out the 14. I'm going to make it an 11, and instead of a Class A non-person misdemeanor, it's going to be a Class B non-person misdemeanor. Okay. All right, so Caleb has pled no contest, and I think, Ms. Moody, you were about to give us a factual basis.
I was.
Okay, thank you. You would.
So on January the 8th, 2020, here in Douglas County, Kansas, Caleb was attending school at, sorry, no, it's here.
I believe it was LHS. LHS.
Okay. He was attending school LHS. He had apparently had some issues with some perhaps bullying from other students towards him. So he took his dad's gun and brought it to school, saying that it was for self-protection and that he wasn't planning on using it but for, or if, unless somebody carried through with these bullying threats they were making against him. And this was at LHS, which is a USD 497 school. Classes happened to be in session at the time. And of course, he did not have permission by anybody to have a gun at school. And this was in Douglas County.
All right. Do you have any reason to believe the state cannot produce that evidence at trial, Ms. Blair? All right. Amend my journal entry here. So the court will find that Caleb entered a no contest plea pursuant to KSA 38-2345 to one count of criminal use of a weapon, a Class B non-person misdemeanor. The court will find upon inquiry that that plea is knowingly and voluntarily made. The factual basis constitutes proof beyond a reasonable doubt. That plea will be accepted, and Caleb will be adjudicated as a juvenile offender of one count of criminal use of a weapon, a Class B non-person misdemeanor in violation of Kansas Statute 21-6301A11. The court will order a pre-sentence investigation. The court will order, well, actually, Ms. Moody, does the state have a motion?
Judge, we're going to be filing amended, so it will not have that count on there.
Okay, never mind. The court will make the order at this point for Caleb to write a letter of apology to the school. And the court will order a mental health evaluation. Does the court need to do anything else today besides set a sentencing date, Ms. Moody?
No, Your Honor.
Ms. Blair? Okay. Now we're cruising. Mr. West, 45 days? 30 days?
I think 30 days would be fine, Your Honor.
Okay. How about, Ms. Moody, I'll ask you first, how is December 16th at 1:30?
Works for the state.
Ms. Blair? All right, Caleb, are you free then?
Yes, sir.
All right, great. Court will set this for sentencing on the 16th day of December 2020 at 1:30 p.m. Anything else we need to do today before we close the record, Ms. Moody?
No, thank you, Judge.
Ms. Blair? Great. Thanks, everybody. Court is adjourned. Parties are excused. We're off the record. Thanks, everybody, for working through it.